Imagine a 73-year-old grandmother named Linda. Linda paid off her home in 1998. She raised 4 kids in that house. She hosted Thanksgiving there for 31 years straight. She painted the kitchen yellow the summer her first grandchild was born. Linda's house was her life. Linda died 3 months ago. She had a will, a simple one-page will she signed in 2010. She thought she was covered. She told her kids there was nothing to worry about. But Linda's kids just got a letter in the mail last Tuesday. The letter came from the probate court. The letter said the house has to go through full probate. The letter said they owe 9 months of back property taxes because nobody was authorized to pay them. The letter said the lawyer's fees will eat roughly 40% of the equity. The letter said they have 90 days to come up with the cash or the house sells at a courthouse auction to the highest bidder. Linda followed the old rules. Linda did exactly what her own mother did in 1987. Linda sat down with a lawyer once, signed a will, put it in a drawer, and walked away thinking the job was done. But the rules just changed. 3 states changed their inheritance tax codes last year alone. 11 states rewrote their probate procedures. The IRS quietly updated the instructions for Form 706 in November, and Linda's family did not hear about any of it. Nobody told them. They did not know their mother needed 6 more documents. 6 documents that take 1 afternoon to sign. 6 documents that lock the house down for the kids for good. 6 documents that took Linda's family from safe to broke in just 3 weeks. And a quiet new ruling from a federal appeals court just made the threat national. A 7-2 ruling. 7 judges said yes. 2 judges said no. They said the old paperwork is no longer enough to protect a home from probate. They said the new paperwork is now mandatory. They said if you do not file these 6 documents before you die, your children do not automatically inherit the house. The court called it the inheritance gap. Estate lawyers are calling it the probate trap. Families across the country are calling it a nightmare they never saw coming. Today, we are going to walk through all 6 of those documents step by step. Plain English, no legal jargon. By the end of this video, you will know exactly what each document is called. You will know exactly what it does. You will know exactly who to call. You will know exactly how much it costs in your state. And you will know the exact words to say to the lawyer so he does not pad the bill with 60 minutes of unnecessary chatter. Let me explain why this is happening to you right now, and why your family is at risk before you finish your coffee. This is not political. This is not about the election. This is not about the news cycle. This is about your house. Your name is on the deed. The roof over your daughter is the same roof over your head. The bedroom your grandkids sleep in every July is the same bedroom where you slept as a child. The mortgage you finished paying in 2007 sits quietly in your memory. The kitchen where you bake the birthday cakes has flour dust on the cabinets from this morning's frosting. All of that can be lost, not because of a storm, not because of a fire, not because of a flood, but because 6 pieces of paper are missing. 6 pieces of paper that would take 3 hours to sign. That is the threat, that is the warning, and that is what we are solving right now in the next 12 minutes. Before we get into the 6 documents, let me give you the truth about what this channel does. This channel tracks property rights. The second they change, we watch the new rulings, we read the new statutes, we map the inheritance code state by state, line by line, we dig into the IRS forms that most accountants skip over, we translate 40 pages of legal English into 20 seconds of plain talk, and we publish it here before the lawyers even finish their continuing education credits for the year. If you want this information in your corner before you need it, hit subscribe. It takes 2 seconds and it could save your family 3 years of courtroom battle. The bell icon, hit that too. That way you get the next urgent update the moment it drops into the news. This is not entertainment, this is survival, and your family is counting on you to pay attention for the next 12 minutes. Pay attention now. Here is the core legal problem. The problem is a collision. On one side, you have your right to own property. You bought the house, you paid the mortgage. Your name is on the deed. That is the American right of private property. Strong, old, protected by centuries of common law. On the other side of the collision, you have the state's right to collect tax and settle debts. When you die without the right paperwork, the state steps in. The probate court takes over. The court appoints a person called an administrator if there is no will, or an executor if there is a will but no trust. That person lists everything you own. That person values everything you own at fair market rates. That person uses court-approved appraisers. That person publishes a notice in the local newspaper so any creditor can come forward. That person pays every debt you owe, every medical bill, every credit card balance. Then the court takes its statutory cut. Then the lawyer takes hourly fees. Then the executor takes a fee. Then the leftovers, if anything is left, go to your kids. That is the collision. Your private property meets the state probate machine, and the state probate machine wins every single time, unless you file 6 specific documents before you die. 6 documents that the court is forced to recognize. 6 documents that say in writing, do not probate this house. Do not appraise this house. Do not auction this house. Do not give this house to the tax man. Send it directly to my named heirs. Skip the courtroom. Skip the fees. Skip the 18 months of delay. That is the legal collision. Your property rights versus the state's tax rights. And the 6 documents tilt the scale back to your side. Without them, the state wins. With them, your family wins. It really is that simple. It really is that dangerous. Let me explain why this trap is so common, because most people do not know they need these 6 documents. They think a will is enough. They think naming their daughter on the bank account is enough. They think joint ownership with their spouse is enough. They think if they have been paying their property taxes for 40 years, the state will leave the house alone at death. None of that is true anymore. As of January 1st of this year, 17 states updated their probate codes. They added new disclosure rules. They added new asset listing forms. They added new waiting periods before transfers. They added new fees on top of fees. The IRS updated Schedule A of Form 706 in November. The new instructions say any property held only in a will but not in a living trust will be flagged for what the IRS calls an extension review. That review can take 18 months. During those 18 months, your heirs cannot sell the house. They cannot refinance the house. They cannot move into the house if it was an investment rental. The bills still come, the property taxes still come, the homeowner's insurance still comes, the utility bills still come, and the lawyer sends a bill every single quarter. By the time the court finally releases the house, the equity is gone, the heirs are exhausted, and they often sell at a loss just to make the process stop. That is the trap. That is the inheritance gap. That is what the new court ruling is warning about. But here is where most people get it completely wrong. This is the trap door. This is where families quietly lose their footing and never recover. Listen carefully. The 6 documents are not a shield that automatically appears when you die. The shield only works if you have signed it. The shield only works if you have updated it within the last 5 years. The shield only works if you have funded it correctly. The shield only works if you have told your family where it lives. Many people sign the documents. They put them in a fireproof box in the closet. They tell no one where the box is. They die. The family searches for months. The family hires a probate lawyer to conduct a search. The family gives up after 3 months. The documents are lost. The shield is lost. The probate court falls back on the old default rules. The kids lose the house. That is the trap door. You can walk into a lawyer's office today. You can spend $1,800. You can sign every single document. You can walk out proud, and your family can still lose the house in 2034 because nobody could find the binder when the moment came. That is the trap. We are going to fix that today. We are going to tell you exactly where to put the binder. We are going to tell you exactly who to tell about the binder. We are going to tell you the 3 locations where you must keep a copy. And we are going to tell you the one thing you must never write on the cover of the binder. Stay with me. We are about to go through all 6 of the documents, one by one. We will cover the exact legal name, the exact purpose, the exact average cost in your state, and the exact mistake that voids each one. This is the protocol. Take notes, write this down, send this video to your children, send this video to your brother, send this video to your neighbor who just turned 65 and is proud of the house he paid off last fall. These next 12 minutes might be the most valuable 12 minutes of their entire year. Let me start with the first document. The first document is called the Revocable Living Trust. Lawyers call it the RLT. Some lawyers call it a living trust. Some lawyers call it an inter vivos trust. Some lawyers call it a family trust. They are all essentially the same thing. The living trust is the master document. It is the umbrella. It covers the house. It covers the primary bank account. It covers the brokerage account. It covers the second car. It covers the small business in many cases. You sign the trust once. You name yourself as the initial trustee. That means you keep full control of every asset while you are alive and competent. You can sell the house. You can refinance the house. You can rent the house to a stranger. You can take out a home equity line. You control it exactly like you did before. The trust only kicks in when you die, or if you become incapacitated through illness or injury. When that happens, your chosen successor trustee takes over. They follow the rules you wrote into the trust document years earlier. They do not have to ask the court. They do not have to wait for a judge. They simply execute your instructions. They pay your final debts out of the trust. They file your final income tax return. They prepare and sign the new deed that transfers the house directly to your children. That is it. No courtroom, no 18-month wait, no 4% probate fee to the state, no realtor commission because the house was never listed. The cost to set up a revocable living trust in most states today is between $1,500 and $3,500. The cost to your family of skipping it is often between $20,000 and $80,000 in avoided probate fees and lost equity. Step 1 is settled. You need a living trust. If you do absolutely nothing else after watching this video, do this. Document number 2 is the transfer on death deed. Some states call it a TOD deed. Some states call it a beneficiary deed. Some states call it an inheritance deed. Some states call it a revocable transfer on death deed. It is not available in every single state. You must check your state's rules. As of this recording, 32 states have made the transfer on death deed legal. The other 18 states have not yet. If your state is one of the 18, you can substitute a ladybird deed in some cases. We will cover that separately. But for the 32 states that allow it, the transfer on death deed is one of the most powerful and underused tools in estate planning. It is brilliant in its simplicity. You sign a brand new deed at the lawyer's office. The new deed names your children as the automatic new owners of the house the moment you die. You keep full and complete control of the house while you are alive. You can sell it, you can mortgage it, you can live in it until the last breath. The day you die, the death certificate triggers the transfer. Your children get the house free and clear. No probate, no court, no waiting period, no appraisal. You sign it at the lawyer's office. You walk it down to the county recorder. The recorder stamps it. The deed is filed and active. The deed sits quietly in the public record for decades. The moment the death certificate is filed, the transfer happens automatically. The cost of a transfer on death deed is between $250 and $750 depending on the state recording fees. That is it. That is the second document, but be careful. The TOD deed does not protect you if you become incapacitated. It only works at death. For incapacity, you need document number 3. Document number 3 is called the Durable Power of Attorney for Finances. Some lawyers call it a DPOA. Some lawyers call it a Financial Power of Attorney. Some lawyers call it a Property Power of Attorney. This document names a person. That person is called your agent or your attorney in fact. That person has the legal right to act fully on your behalf if you cannot, if you have a major stroke, if you develop dementia, if you fall into a coma, if you are simply too weak to handle your own bills. Your agent can step in immediately. They can pay your mortgage payment. They can pay your property tax bill. They can file your homeowner's insurance claim after a storm. They can manage your investment accounts. They can roll over your IRA. They can even sell the house if the medical bills demand it and the trustee agrees. The durable power of attorney for finances must be signed while you are still mentally competent. It must be notarized in every state. It must be witnessed in most states. The cost is between $200 and $600 for the document at a lawyer's office. The savings, if you ever need it, is essentially priceless. Without a durable power of attorney for finances, your family must go to court. They must ask a probate judge to appoint a conservator or a guardian for you. That court process costs between $5,000 and $25,000 in legal fees alone. It takes 6 to 12 months. During those months, your bills go unpaid. Your house is at risk of foreclosure for one missed payment. That is exactly what we are preventing with this single document. Document number 4 is the Advanced Healthcare Directive. Some people call it an AHCD. Some people call it a medical power of attorney. Some people call it a healthcare proxy. Some people call it a living will. This document does not relate to the house directly, but without it, your house is at severe risk. Let me explain how. If you cannot make your own medical decisions, your family will fight. They will fight about whether to keep you on life support. They will fight about which hospital to use. They will fight about which doctor to trust. That family fight often ends up in court. Court means lawyers. Lawyers mean fees. Those fees come directly out of your estate. The estate includes the house. So the equity of the house shrinks while the family fights in court about whether to pull the plug. A simple Advanced Healthcare Directive names one single person to make medical decisions for you. It states your wishes in writing. It removes the decision burden from your children. It prevents family fights. It prevents court interference. The cost of this document is between $100 and $400. The peace of mind is permanent. Sign this document. Keep a wallet card that says you have one. Give a copy to your primary care doctor. Give a copy to the person you named. Give a copy to the backup person too. Document number 5 is the HIPAA authorization form. This sounds like a hospital form, but skip it and your house is in danger. Let me explain how. HIPAA laws keep your medical information absolutely private by federal regulation. Even your own adult children cannot legally access your medical records without your written permission. If you cannot speak for yourself, the hospital cannot tell your family anything about your condition. The doctors cannot coordinate. The billing cannot be processed by your durable power of attorney agent. Everything freezes in place. The medical bills pile up. The mortgage payment is missed. The property tax payment is missed. The homeowner's insurance lapses, the house goes into default, the bank sends the foreclosure notice, the house sells at auction for pennies on the dollar. A HIPAA authorization form is a single page. It names the people who can access your medical information. It names the people who can legally talk to your doctors on your behalf. It names the people who can coordinate your care. Sign one for each of your adult children. Sign one for your durable power of attorney agent. Sign one for your primary doctor. Sign one for the local hospital. The cost is essentially zero. Most lawyers include it free with the durable power of attorney. The protective value is unlimited. Without it, your healthcare emergency can collapse your entire estate in 90 days. Document number 6 is the last will and testament. Yes. The will. Even if you already have a living trust, you still need a will. Many people get confused here. They think the trust replaces the will entirely. It does not. The will still has a critical role. In estate planning, the will is called a pour-over will. Its job is simple and elegant. It catches anything that did not make it into the trust. It tells the court to send any leftover property into the trust upon your death. It names a guardian for any minor children. It names a guardian for any dependents with disabilities. It names a personal representative to handle final loose ends and unresolved debts. Without a will, the state decides who gets your property. The state decides who raises your grandchildren. The state uses a rigid formula that ignores your actual wishes and ignores the family relationships you spent 40 years building. A simple will costs between $300 and $800 at most lawyers. Make sure your will is signed in blue or black ink. Make sure your will is witnessed by 2 adults who are not named in the will. Make sure your will is notarized in your state if your state requires it. Make sure the witnesses are not your heirs. Witnesses who are also heirs can be challenged. That alone can void the will in some states. Take this seriously. Now, let me give you the protocol, the exact steps to take, the exact order, the exact way to leave the lawyer's office finished. This is the part most YouTube videos skip. This is the part your family actually needs. Write this down. Take notes. Send this to your children. Send this to your brother. Send this to your neighbor who still believes his 1995 will is doing the job. Step 1. Call a licensed estate planning attorney in your state this week. Do not use an online template. Do not use a generic form downloaded from the internet. Do not use the trust form your cousin printed out for you. The laws are wildly different from state to state. A California trust form is not valid in Florida. A Texas deed is not valid in New York. A Pennsylvania will is not valid in Tennessee without review. Spend the $1,500 to $3,500. Get the right documents for your specific state. Get the right advice from a real attorney. Get the peace of mind that comes from knowing it was done correctly. Step 2. Schedule one single afternoon. Block out 3 hours. Bring your spouse if you have one. Bring your most recent property deed. Bring your most recent mortgage statement. Bring your life insurance policy declarations page. Bring the latest brokerage statement. Bring your existing will if you have one. Bring your existing trust if you have one. The lawyer can complete all 6 documents in that single session. You walk in around 1 o'clock. You walk out around 4 o'clock. You do not need 6 separate appointments. You do not need 6 separate billings. Step 3. Sign every document carefully. Date every document. Initial every page where required. Have the 2 witnesses in the room with you. Have the notary ready. Sign a few forms. Step away for a glass of water. Sit back down. Sign the next batch. Do not rush. Mistakes in signatures can void the documents entirely. Use your legal name exactly as it appears on the current deed. Use blue ink if your state requires blue ink. Use black ink if your state requires black ink. Ask the lawyer. Follow every instruction to the letter. Step 4. Record the public documents right away. The transfer on death deed must be physically recorded with the county recorder's office. The living trust does not need to be publicly recorded, but a 1-page memorandum of trust should be filed so the title company knows about it. The will should not be recorded publicly. Keep the will sealed in your fireproof safe until the day it is needed. Step 5. Make 4 identical copies of every single document. 1 copy goes in the fireproof home safe bolted to the floor. 1 copy goes to the lawyer's office in a sealed envelope marked with your name. 1 copy goes to the primary child or trusted family member you selected. 1 copy goes to your safety deposit box at the bank as a last resort backup, but do not put the originals in the safety deposit box. Banks frequently freeze safety deposit boxes at the death of the holder. The family cannot retrieve the documents without a court order. That court order takes weeks. The originals must be accessible in the first 72 hours after death or the whole plan collapses. Step 6. Tell 3 specific people. Tell your primary adult child. Tell your lawyer. Tell your primary doctor. They must know about the documents. They must know the exact location. They must know the master password for any digital copies. They must know the filing location of the deed in the county recorder's office. If you keep this a secret, your family will lose the house just like Linda's family. That is the trap door. That is the entire trap in plain sight. Do not be Linda. Tell 3 people today. Now, let me give you the 6 biggest mistakes to avoid. Mistake number 1 is letting your children sign as the witnesses on your will. In the majority of states, an interested witness cannot sign a will. If your daughter signs as a witness, she can be cut out of the will entirely by challenge. Use neighbors, coworkers, or friends who are not named as beneficiaries. Mistake number 2 is naming only one child as your agent on the durable power of attorney for finances. Always name a backup, always. Things happen, people get sick, people relocate, people die before you do. Name a primary and a successor. Mistake number 3 is buying the cheap online trust and walking away. The trust document is not the actual trust. The trust is the funding. The lawyer must transfer the house deed into the name of the trust. The lawyer must transfer the bank account into the trust. The lawyer must transfer the brokerage account into the trust. The lawyer must transfer the life insurance policy review into the trust structure. If any of those transfers are skipped, the trust is hollow. The house goes through probate anyway. The savings evaporate. Mistake number 4 is forgetting to update the documents after a major life event. Marriage, divorce, death of a child, birth of a grandchild, a move to a new state, a new inheritance, a new significant asset. Each one triggers a mandatory review. Update every 5 years at a minimum. Mistake number 5 is keeping the originals of the will in a bank safety deposit box. Banks routinely lock those boxes at death. The family cannot retrieve them without court paperwork. That paperwork takes weeks. Keep the originals at home in a fireproof safe and only store copies at the bank. Mistake number 6 is telling no one about the documents. The documents are useless if the family cannot find them. The documents are useless if the family does not know they exist. The documents are useless if the family does not know the attorney's name and number. Tell 3 people. That is the rule. Tell 3 more. Let me also tell you the 4 places you must keep your documents safe. Place 1 is a fireproof home safe bolted to the floor in a hidden but accessible location. Place 2 is the lawyer's office in a sealed envelope inside the client file. Place 3 is a copy in the hands of your primary adult child or trusted relative. Place 4 is a scanned PDF stored in a secure encrypted cloud service like a password-protected family folder inside a reputable provider. Digital is good, paper is better, both is best. Let me tell you the 3 conversations you must have this month. Conversation 1 is with your spouse. Sit down together, show them the binder, walk through the trust, walk through the transfer on death deed, walk through the durable power of attorney. They must understand every word of it. They must know exactly where it is. Conversation 2 is with your primary adult child. Walk them through the documents. Walk them through the location. Walk them through the lawyer's name and number. Walk them through the master password for any digital copy. Give them a sealed copy for safekeeping. Conversation 3 is with your primary care doctor. Bring the HIPAA authorization. Bring the advanced healthcare directive. Have the front desk scan both into your medical record. Have them placed at the very front of the chart. Have them flagged for emergency access. Let me also tell you the cost breakdown truth. Many viewers ask, what does all of this cost in real numbers? Here is the honest average. A revocable living trust runs $1,500 to $3,500. A transfer on death deed runs $250 to $750. A durable power of attorney for finances runs $200 to $600. An advanced healthcare directive runs $100 to $400. A HIPAA authorization is usually free. A last will and testament runs $300 to $800. The total package at one lawyer in 1 3-hour sitting is between $2,500 and $5,500 in most states. The savings for your family down the road is between $20,000 and $100,000 in avoided probate costs, attorney fees, and lost equity from forced sales. That is a 10 to 20 times return on every dollar you spend today. There is no better investment you will ever make in your entire life. Let me also explain the timing truth. Timing matters more than people realize. You are not too young, you are not too healthy, you are not too busy. If you are over 60, the average life expectancy gives you roughly 25 more years. 25 years for something unexpected to happen, 25 years for a stroke, 25 years for early dementia, 25 years for a serious car accident on the way to the grocery store. The documents must be in place today. The documents cannot wait for the next birthday. The documents cannot wait for retirement. The documents cannot wait for next spring. The documents are your emergency parachute. You do not wait to pack a parachute until the plane is falling out of the sky. You pack it before takeoff. This is the takeoff. Pack it now. Let me also tell you what to do if your parent has already passed away. If you are watching this video and your mother or father already died without these forms, the playbook is different. But you can still save the house in many cases. Hire a probate attorney within 14 days of the death. Do not pay any debts out of pocket until the lawyer reviews them. Do not sell any property until the lawyer reviews the title. Do not sign anything at the courthouse without reading it 3 times and asking the lawyer to explain it. The lawyer can often negotiate the medical debts down significantly. The lawyer can often combine multiple legal filings into one efficient action. The lawyer can often push for an expedited probate if the heirs are low income or the estate is small. You still have rights. You still have options. But you must move quickly. The longer you wait, the more equity you lose. The longer you wait, the more fees pile up. The longer you wait, the more chances the creditors take what they want. One more warning before we close. Watch out for the scams. There are scam artists today showing up at the doors of seniors. They call themselves estate planners. They call themselves living trust specialists. They offer a free dinner at a local restaurant. They offer a free will at a senior center luncheon. They offer a free living trust at a hotel breakfast. Many of these are legitimate seminars. Many are not. Some are selling overpriced boilerplate documents that will not hold up in your state. Some are selling unnecessary insurance products. Some are stealing your personal information outright. Never sign anything at a free dinner. Never sign anything at a hotel breakfast. Always hire your own attorney through your own referral. Ask the Bar Association in your state for a list of certified estate planning attorneys. Ask your financial advisor. Ask your accountant. Ask your adult children. Do your own vetting. Avoid the high-pressure sales pitch. Avoid the countdown timer on the table. Avoid the man in the suit with the laminated folder and the too friendly smile. Trust your gut. Trust the lawyer you chose first. Let me close with this. The 6 documents are not a luxury. They are not for the rich. They are not for celebrities with mansions. They are for the grandmother in the small bungalow. They are for the veteran in the duplex. They are for the retired teacher in the townhouse. They are for the small house in the small town with the big Sunday dinners. The mortgage is paid off. The kids are grown and scattered. The grandkids come home every summer. The house is full of memories and full of love. That house is your legacy. That house is your family's anchor. That house is at risk. Today, in your state, under these new rules, your house is at risk, but it does not have to stay at risk. 6 documents, 3 hours, 1 afternoon. That is all it takes to lock it down for good. That is all it takes to keep the house in the family for another generation. That is all it takes to keep your name on the deed until the day you choose to pass it forward. Hit the subscribe button right now. Hit the bell icon. Share this video with one person over 60 in your family before the weekend. Send it to your dad. Send it to your aunt. Send it to your neighbor who just mowed his lawn this morning and is proud of paying off his house last fall. The clock is ticking. The paperwork is waiting at the attorney's desk. The law is moving every single month, and your family deserves to keep the house. Do not let them lose it because 6 pieces of paper were never signed. Do not let them lose it because nobody told them. Do not let them end up like Linda's children, holding a letter in the mail, watching everything their mother built disappear in 90 days. Sign the documents. Tell 3 people. Save the house.